Good morning. I know that many friends are still coming in. Please do come in and join us. It's wonderful to have some friends. Hopefully many more will join us in today's very happy day of the 25th anniversary of the convention. So I think we should start by saying happy birthday, Convention on the Rights of the Child, and all of us who are celebrating it around the world. It's a real pleasure to welcome such a wonderful group of panelists and participants in this meeting. And everyone brings such a wonderful experience that I'm sure that we will leave even more re-energized than we are usual. I am very, very honored by the fact that we have with us wonderful colleagues who have been in the past participating in the drafting of the Convention on the Rights of the Child, serving in the Committee on the Rights of the Child. We have the current chair of the committee, the special rapporteur on the sale of children, child prostitution, child pornography, and each and every member who is sitting at the table, in fact, have been incredibly active in promoting the rights of the child across regions. And we would like to start the morning by just bringing a flavor of what the General Assembly looked 25 years ago. And so we will show and share with you a little video of the fundamental moment of the adoption, formal adoption of the Convention on the Rights of the Child by the President of the General Assembly and the Secretary General. So, in a second.
30 years after the adoption of the Declaration of the Rights of the Child, the United Nations has given the global community an international instrument of high quality, protecting the dignity, equality, and basic human rights of the world's children.
The task before us now is to give reality to the promises of the Convention by bringing it into force and applying it worldwide. It is so decided.
Well, keeping the promises of the convention, it is so decided. But unfortunately, we are not yet there. But certainly, we are moving towards it. And we hope that this anniversary will be the turning point for it. I wanted to start very briefly by recalling some of the dimensions that make this convention so special. And we all believe that it is very unique, of course. And it is wonderful to recall that the convention brought forth a new vision of childhood. Until then, children were considered to be members of the family, students participating in schools. With the convention, we envisage children as subject of rights, as citizens of today, as agents of change. And this was the reason why the convention not only recognized the right of the child to be consulted and to influence decisions, but also the responsibility of states to convey information to children in a manner that children can understand and can use on their daily lives. So an important shift in the way we look at children. But in addition, as you will recall, the convention was drafted over a period of 10 years when the world was very polarized and there was so much confrontation. And the convention raised children above politics. It bridged different legal systems and allowed us to overcome economic, social, political, cultural differences in mobilizing the world behind this wonderful dream of realizing the rights of the child for all children everywhere and at all times. The convention was the first treaty that was drafted in the United Nations with a wide participation of countries from all regions, from the north and from the south, from the east and from the west. And for the very first time, it involved actively civil society organizations. And we see the fingerprints of civil society participation in so many of the provisions of the Convention on the Rights of the Child. But in addition, the convention was drafted with the active participation of bodies and mechanisms from the United Nations system. And this allowed the treaty to benefit from the experience and expertise of so many agencies within the United Nations system and anticipate their involvement and responsibility in the implementation process that would follow. And this has, in fact, brought a new vision that we will address in greater detail, a new vision of how development cooperation needs to be informed by and leading to an investment in the promotion and protection of the rights of the child. This is why today the Committee on the Rights of the Child can not only emphasize what states need to do, but can only anticipate how things can be done with the support of UN agencies, civil society organizations, and many other actors, including regional organizations. So the convention brought us an opportunity to really foster the mutual learning from different experiences and expertise, and brought us into a different paradigm of what international solidarity is about around children and around the realization of their rights. The other dimension I believe is very important to recall is that the convention set minimum standards, below which no state is allowed to go. So the convention recalls that passivity or indifference are not allowed. It requires that states monitor periodically what they are doing and the impact of what they are doing, and it requires states to report back on progress achieved, and that's where the committee has such an important role in monitoring what this means for children around the world. And for this reason, the convention, in fact, was humble in recognizing that the rights of the child and the universe of children are an evolving reality. And for this reason, it required states to always apply the most conducive norm to children. It may be in the national legislation, in a regional treaty, or in a policy at the national level. And at the same time, it also required or gave the committee the opportunity to ask for studies to go deeper into some of the emerging concerns. And this is why we have today, as you know, the Grassa-Michel study on children involved in armed conflict, the Paulo Pinheiro study on violence against children, which today still set a number of important recommendations that are guiding so many of the things we do in the UN at the regional and national level. These are very important highlights in my view, just a few that we will address in with deeper attention by the panelists, but there are two other things I would like to recall. One is that the convention, in fact, has been the source of inspiration of so many other treaties. Just to mention a few global treaties adopted by the United Nations system, we can think about the ILO Convention on the Worst Forms of Child Labor. We can think, of course, about the Convention on the Rights of Persons with Disabilities, but we can also think about so many regional treaties or the Convention on Intercountry Adoption. I could go on in my list, but of course the Convention has also been complemented by three very important optional protocols, and we will address them in a second. But in addition, and that's the final point I wanted to stress, the convention has become a guiding reference for work at the regional level. I'm so pleased that we have different regional organizations represented here today, but it is so fascinating to recall the impact of the convention in the African Charter on the rights and welfare of the child, on the work of the League of Arab States, of the Council of Europe, of the Inter-American Commission and Court, on the ASEAN Commission on the Rights of Women and Children. I think I could go on with a list referring to SARC and many other aspects at the regional level. So the convention has not been crystallized in 1989. It has set in motion a process of change and an inspiring demand for always the best possible solution for children. And we will have an opportunity to feel reignited by this wonderful vision and the mission that we have been committed to pursue all these years and remain committed to pursue in the future. We hear children say what we want from the world is that our world becomes at the level, at the ambition of our dreams. I think they deserve no less, and I'm sure you will join us in achieving perfection, if we can. So I would like now to start by giving the floor to our first panelist. Unfortunately, he was not able to join us in person, but we will have a video. Thomas Hammerberg was an active member of the drafting of the Convention on the Rights of the Child, a member of the Committee on the Rights of the Child, the former Commissioner for Human Rights in the Council of Europe, and he remains a very active ambassador for children. So we will listen to him speaking about the best interest of the child.
After the Convention on the Rights of the Child was adopted by the General Assembly 25 years ago, and after a number of governments had ratified the treaty, an oversight body could be elected. It fell upon this, the Committee on the Rights of the Child, to present a more detailed interpretation of the Convention. We defined 4 general principles which would guide the understanding of the substantive articles in the Convention. A key principle was the principle on the best interest of the child. This principle was mentioned in several articles, for instance, those on parental responsibilities, foster placements, and juvenile justice. But it was in Article 3 where the deeper meaning of this principle became clarified. The article said that in all actions concerning children, the best interest of the child should be a primary consideration. The scope was indeed wide. The obligations covered not only governmental authorities, but also the court system and the legislative bodies, and also the private social welfare institutions. Of course, there was a discussion about the interpretation of this article, and there have been many misunderstandings. One was, in fact, that it could be of help for a child that it suffered corporal punishment, that would give the child a lesson for the future. This is, of course, a misinterpretation of the whole intent behind this article. The best guide when it comes to defining what is good for a child is actually to go through the articles one by one in the Convention. And particularly important is the notion that we should listen to the views of the child, which is stated in Article 12 of the Convention. So when we define what is good for the child, the best interest of the child, we should take very much in mind the views of the children themselves. Another discussion has been based on the fact that the Convention says that the best interest should be a primary consideration and not the primary consideration. And the reason for this, of course, is the wide scope of this principle, that children's interests should be guarded in very many settings. And therefore, there could be a conflict of interest between the child's interests, the parent's interest, economic interest, and the interest of the society as a whole. And this is not meant to undermine the importance of the principle of the best interest of the child, but it points at the need for some procedures in order to take wise decision on the balance between the interest of the child and other legitimate interests in the society, and in a way that protects the rights of the child and the basic principles there. Unfortunately, we have not seen this ambition to develop procedures which would guarantee that the interest of the child would also be protected in situations where there are conflict of interest. And not sufficiently many governments have tried to develop good procedures there in the spirit of the rights of the child. In fact, we have here an implementation gap. We who have served in the Committee on the Rights of the Child through the years, we are convinced that the full implementation of the principle of the best interest of the child would dramatically increase the status of children and their rights in our world today. Therefore, we do recommend that higher priority is given to this crucial principle in the best interest of the child.
Well, thank you. Thank you, Thomas, who may be watching us in Sweden, although he's speaking in another event also on the convention. Thomas mentioned, of course, very strongly the importance of listening to the voice of children, the views of children. And I think it makes really good sense to now give the floor to Trond Vaga, who was a former ombuds for children in Norway, the first country to have an ombuds for children, but who is at present in the University of Telemark and is the chair of the International Institute for Future Generations. The ombuds safeguards and amplifies the voice of children, and we want to listen to the voice of Trond now, please.
Thank you so much, Martha. It's some time back when we started this in Norway, the Ombuds Office system. It was in the early, actually, 69. And to a debate on, I just have to find my things there we are. When we had the revision of the National Children's Act in '69, and the argument for setting up an independent ombuds office in Norway was, of course, that children was constituted a large but vulnerable group without any organization or any other efficient voice to plead their interest. So in 79, we had the International Year of the Children. And that was an important contribution factor to move the agenda forward. And after several debates in the Norwegian National Assembly, Act number 5, an Ombudsman for Children, was passed in '81. The Ombuds should be an independent agency, free to criticize both public authorities and private bodies, with objectives to safeguard children's interests and rights. This was 10 years before the convention, and in 1993, the Norwegian Parliament asked for an evaluation of the Ombuds Office based on the reason that the institution had been in place for nearly 12 years without any studies of its objectives or impact had been made. And this was my first contact with the Ombuds Office in Norway, because I was a part of this group or committee who evaluated the office. The committee concluded in 1995 that the office had been fulfilling the mandate and recommended that it should be maintained as an independent national body for safeguarding the best interest of children. Of course, there was also opinion against setting up the office, and very much related to that it was threatening parental authority. So this was the start. After that, we had a convention, we had a committee, and promoted both by UNICEF and the civil society, especially SAVE, which was strong in all regions of the world, supporting this new mechanism of monitoring. The International Parliamentarian Union, academia, and others. This movement started worldwide. And I remember within the 8 years I was an ombud, I was involved in setting up 20 offices around in Europe and also some in Africa. And sometimes it went too quick as a kind of a response to an international expectation that you should do it because the committee is talking about it. So some of the office setup was really based on very fragile foundation in the way it was done, and some of them also fell down very quickly. But the governments and parliaments, they did request guidance, best practice, and data. And thanks to Innocenti, UNICEF Innocenti, the research center, where Marta was the director, the ombuds system has been monitored by the center and follow up organizing conferences and meeting and workshop. And after this enormous call from governments, finally we set up the research, which was published then last year or in the end of 2002, which is the Champion Children's Rights, which is a mapping worldwide on what exists and all kind of suggestions and learning points meant for parliaments and governments to get ideas. So it is not stating one model of how to do it. 200 independent institutions were in the survey in 70 countries. And the one and only model we cannot read from this survey or this research, because it's different models, but there is a common platform for all of them, and that is that they're monitoring the rights of the child. And all models can also show successes they've done, whatever, if it's independent separately or independent integrated, half integrated, or fully integrated in human rights institution. But what we found is that some of the officers was quite lonely in the work they were doing, so they needed a kind of a supporting mechanism. And what we found for the one who had the best success is that if you have a parliament or a government or civil society and research community who could support that in a better way than just coming up when needed, but organize it in a system that is good, like the civil society, that the NGOs could be critical friends working alongside with the ombuds, but also pointing out where performance requires strengthening, sharing information and all that. And the parliament, which we have been working on together with the IPU, the International Parliamentarian Union, create cross-party child rights group or child rights commission in the parliament to help to ensure a broad support across political parties represented in the parliament, and to safeguard more holistic approach on children's issues debated in the parliament. Also the research community, which is important to have with us and work together with the ombuds system in moving the child rights agenda forward. Research, knowledge, production, evaluation, solid documentation plays a reassuring role. And it also avoids the ad hoc policy making, which is based on anecdotes and more promote informed-based policymaking. And also, of course, at least the government, the interdepartment child rights group in the government, which some of the countries now have set up, to encourage the government to establish a permanent interministerial child rights group with the mandate to coordinate and monitor government's initiative on implementing child policies. So if you have, this is a kind of a five-pod, which is working together, and they are strengthening each other. So if one fell down, there are still four. But if it's only the Ombuds Office working completely isolated, oh gosh, that is some challenges ahead. One thing I need to say is, which is important for what we have read from the report too, that is the perception of the child in the society. Because the traditional accounts of childhood set by the developmentalists like child psychology and development is that children is merely adults in making. Such a view judges children only in terms of what they will become in the future once they have been adequately socialized. In the meantime, they are seen as inherently vulnerable, incomplete, and dependent. This view encourages a charity approach policy, which is also then found in public administration as well as in parliaments. This view anatomizes the child, and different sectors take the parts of the child. So we can see that in the way we organize the service system of the child by labeling it. Child psychiatry, they talk about the patient. Child Protection Authority talks about the client. Educational Psychology Service, the case. The educational system, the student or the pupil. In sport, we're talking about the talents. In politics, we talk about the expenses or the problem. In youth organization, we talk about members. And in the CRC, we talk about articles. So where is the child? In a way, we have been so professional in the way we're searching to help the child that we also are distancing ourselves completely from the child, which is a danger. And we can see that in politics, and it became more and more the understanding of a charity approach in the politics instead of the child rights approach. So this is preserving a mindset that is defined by the sectorial logic, and that is something we have to address for the next 25 years to change. Because the new perception of childhood is that we should perceive these children with a new status of citizen and agents for change, as Martha mentioned, acknowledged as a resource with their ideas, creativity, expectation, demands, and inspiring ability of influencing decision, enriching our vision of the world. Investing in children is becoming perceived more and more as a question of good governance and economics, an instrumental step for development of society and democracy. So that is the ethos of the convention, which is in a way above the article, but is also funded on the article, the right to unfold and develop their capacities, the right to master their destiny, to emancipate themselves. As such, the CRC emphasizes the uniqueness of every child and a child's value as a nation builder. As such, we need to challenge the fragmented protection perspective and launch the holistic investment perspective for the next 25 years. So the ombuds for change, in the years to come, there will be a need for a strong ombuds office that are an added value to the establishment and of the protectors of status quo, to challenge the charity approach and encourage the investment perspective in policy making and practice, to perform innovative, creative, flexible and non-bureaucratic way, be a knowledge entrepreneur who acts as a catalyst for change in governance, organizational structures and mindset, work cross-sectorial and holistically, in short, be an ombuds for change. This is the last thing, a small story from a conference I was moderating, and I had some young one who was co-moderators. And Christina, 14 years old, she was sitting beside me on the stage. There were 3 ministers and 3 researchers and 3 civil society, and we had a debate for 1 hour. And she was supposed to do the summing up. And she had prepared herself very clearly by me informing her what they would say. But in the end, 5 minutes before ending, she turned to me and said, "Trond, I'm not going to say what I have prepared." And I was a little bit shocked, so say, "Are you leaving the stage?" "No, you have to trust me." So I introduced her for the summing up, and she went in front of the stage. She turned back to the panel of the 3, she nodded and smiled, and then she turned to the audience, 370 policymakers, and said that, "I just want to remind you, I'm not an article, I'm a complete human being of 14, thank you very much." And she turned around from the stage and went back. And it was completely silence. And suddenly, there was 370 in the audience standing up, applauding for this young girl of 14, saying this one sentence. And for the rest of the conference, she became the icon of holistic approach. Thank you.
Thank you, Trond, to remind, especially for reminding us that the convention is not simply a set of articles. There is a human face behind, strong, empowered, and influential. Now, we are now going to listen to another video message from the colleague who was participating on behalf of Argentina and who will address the right to identity and the right to preserve and reestablish identity. This is a very innovative provision in the Convention on the Rights of the Child. I'm sure you will be impressed by the history he is going to recall.
In 1983, with the democracy, new government in Argentina, we start a new phase in our history on the promotion and protection of human rights. Then in 1984, my country decided to have a very active role on the drafting of the future convention of the right of the child. And in the working group, we decided to have some of our bad experiences as an inspiration for new provisions in this future mandatory instrument in order to accomplish some good level of protection for the future for the children around the world. Our priorities in these negotiations were related to the big violation of human rights that Argentina suffered from 1976 till 1983. And one important aspect of this very bad experience was to try to deal with the question of the identity of the children. We thought that apart from Article 7, that was very important concerning the registration of name, nationality, and other aspects of the identity of the children,
we thought that was necessary a particular provision to protect the identity from any illegal change. Then we work in a very close way with our national NGOs and with the coalition of international NGOs in Geneva at the working group in order to draft a good provision talking essentially to two aspects. One was the notion of identity, something that was quite new for many delegations, not only from developing countries, but from Western delegations, because they consider that perhaps with Article 7 concerning the registration was enough for the protection of identity. We said that, in our opinion, was necessary to have a special provision to talk about illegal acts against the identity of children. And in the second paragraph of this Article 8, we include some wording necessary to not just protect the identity, but to modify the aspects of the wrong identity, like name, family relations, etc., in order to restore the authentic, the truth of the elements of identity of a child. I want to say that for many years we have negotiations about the notion, the definition of identity, and I have to say that we reach a compromise because other countries, even if they didn't have a so negative experience like us, they were ready to cooperate with our delegation, with delegation of other Latin American countries, in order to have this future Article 8, and we got the support also from, in those days, the Center of Human Rights. They are experts, work a lot with us in order to achieve a good wording. At the end of the negotiations, as you know, in 1989, we have the approval of this new mandatory instrument by the General Assembly. A delegation of my country was there in this important moment. I was member of the Argentinian delegation too. And I have to say that from a political point of view, was a very important decision of the General Assembly to give clear indication that the right of the child will be, from that very moment, mandatory. And from a national point of view, it was a very important achievement to have this Article 8 on identity, because we thought in other countries maybe where they will suffer in the future the big problem and crime of enforced disappearances, to have this Article 8 could protect families in the future and could help them in order to have legal procedures in order to restore the truth and in order to reestablish the family relations. Just to say that for us, in 1989 was not the end of a process, but it was a very important achievement even for our legal procedures, because in 1994, when we reformed our national constitution, we include the Convention of the Right of the Child in the text of our own constitution in order to give more protection to the children for the future, more protections for the families, and to recognize the great job of our national NGOs performs in those difficult years. Many thanks.
Thank you so much. I think it's so good to recall and to see the importance that this provision continues to have in preventing, as we heard, disappearances, trafficking, sale of children, but also helping kids who are displaced or who become refugees or are affected by armed conflict to restore their identity and to be tracing their families and go back to a normal life. We are now very pleased to give the floor to Ambassador Anders Ronquist, who was a key member of the drafting group of the Convention on the Rights of the Child and played a decisive role in the provisions on the protection of children from participation in and involvement in armed conflict. And I'm very pleased to give you the floor, Anders. Yeah.
Thank you very much, Marta. It's great to be here at this important anniversary. I'm supposed to talk about the Convention as a mission at all time, and I will focus, as Marta mentioned, on the protection of children in times of armed conflict. First, I would like to make the point, though, that the whole Convention is relevant and applicable also in armed conflict. There are no derogation clauses in the Convention which makes it possible for states to not to apply certain principles in times of war. The first Polish draft of the Convention contained quite a general and abstract Article 8 that the child shall in all circumstances be among the first to receive protection and relief. The Quakers already in 1980 proposed that the Convention should include explicit provisions to protect children from recruitment and participation in armed conflict. They regretted that the 1959 Declaration on the Rights of the Child did not include a standing principle against training children to kill and cripple other human beings and using them in open warfare. It is, however, sometimes sensitive to discuss and elaborate provisions on international humanitarian law standards in human rights fora. Some argue that this is for military experts to negotiate. International humanitarian law still lacks effective compliance mechanism if you compare it to the human rights field. Evolution has, of course, shown how important it was to include such provisions in the Convention in order to enhance the implementation of these principles and lift them to the highest political levels. Algeria, Canada, the Netherlands, Belgium, Finland, Peru, and Senegal followed suit and presented a draft article, as did the NGO ad hoc group. Agreements were quite soon worked out in the working group to insert in what would be Article 38 of the Convention provisions to respect and ensure respect for rules of international humanitarian law in armed conflicts relevant to the child, and to protect and care for children affected by armed conflicts. But it proved extremely difficult to agree on provisions to ensure that children do not take part in hostilities and are not recruited into armed forces. The main difficulty lay in agreeing on the age limit for protecting the child from taking part in war. The Geneva Protocols of 1977 laid down a 15 years age limit, since the majority of states at that time were opposed to extending the ban on recruitment beyond 15 years of age. But in drafting the Convention on the Rights of the Child in the 1980s, a clear majority of states were in favor of raising the age limit to 18 years of age. Algeria was one of the first countries insisting on an age limit of 18 years. In 1988, Sweden put forward a proposal which would have set the age limit for participation in armed conflicts at 18. The deliberations were deferred to the second reading of the Convention in 1989. While receiving a vast support in the working group, a couple of states considered that the working group was not mandated to review existing standards in international humanitarian law, nor was it, they argued, an appropriate forum to do so. Some delegations even argued that we should skip this article from the Convention. In the end, and in order to safeguard the adoption of the Convention during the important target year 1989, we had to go along with standards which did not improve as compared to the Geneva Protocols. But the intensive campaign on this issue by the international NGOs, in particular the Quakers and Save the Children, during and after the negotiations, led to putting the protection of children from armed conflict very high on the political agenda. Perhaps an easier negotiation and agreement on Article 38 would have led to less attention to this subject. The African region showed the way. The African Charter on the Rights and Welfare of the African Child, which was adopted in July 1990, established that states parties shall ensure that no child, that is, no person below the age of 18, shall take a direct part in hostilities and refrain in particular from recruiting any child. The World Summit for Children, convened in 1990 following an initiative by the leaders of Canada, Egypt, Mali, Mexico, Pakistan, and Sweden, led to highlighting the importance of ratifying the Convention and drew also international attention to the horrendous plight of children affected by armed conflicts. In 1994, the UN Secretary General appointed Graça Machel as independent expert to carry out an assessment of the impact of armed conflict on children. Marta already referred to her important study. And her report led to the establishment in 1996 of the Special Representative of the Secretary General for Children and Armed Conflict. Ms. Laila Serougi, the current Special Representative, makes tremendous efforts, not least in order to reach out to and engage non-state armed groups. As she points out in her report to the General Assembly, out of the 59 parties cited for grave violations, 51 are non-state armed groups. In 2000, based on the first draft presented by the Committee on the Rights of the Child, an optional protocol to the Convention setting an 18-year age limit for direct participation in armed conflict and compulsory recruitment was adopted. The Committee on the Rights of the Child, in its important task to monitor compliance with the Convention, also, of course, monitors the compliance with this protocol. And little did we know when we negotiated the Convention that the UN Security Council from 1998 and onwards would bring up its provision on children and armed conflict, in considering that the harmful and widespread impact of armed conflict on children is a threat to peace, security, and development. The Security Council Working Group on Children and Armed Conflict, established in 2005, reviews annual reports on violations against children affected by armed conflict. And the Rome Statute of the International Criminal Court, adopted in 1998, established that conscripting or enlisting children under the age of 15 into national armed forces and using them to participate actively in hostilities is a war crime falling under its jurisdiction. In the Lubanga case, the ICC trial chamber recognized that the distinction between voluntary and forced recruitment is artificial, and recognized also the broader interpretation of the definition of child soldiers to include also girls and boys who serve in support roles. I should add that the ICC Appeals Chamber will come with its judgment on this case on the 1st of December. As has been demonstrated above, since 1989, the plight and rights of children in armed conflict have rightfully found an enhanced priority in the central and high-level discussions on human rights, international humanitarian law, development, and peace and security. It was indeed essential that we included Article 38 in the Convention. The challenges in today's world in this field are enormous, but we have during the last decades developed norms, policies, and mechanisms to address them. The vision has developed into a mission. Thank you very much.
Thank you so much, Anders, for recalling all these important path and the very promising achievements that have been made and the many challenges that persist for children affected by conflict. I'm now very pleased to give the floor to Ambassador Marilia Sardenberg, who was an active member of the drafting of the Convention on the Rights of the Child, representing Brazil, and who was also for many years a member of the Committee on the Rights of the Child. Marilia.
Good morning, you all. I'm very happy to be here because this is a great day, and I'm very happy to participate in this celebration. First of all, I would like to say that I would like to bring you a little bit of my personal experience, not only in the working group, but also in the committee for 12 years. My first contact with the theme of children's rights was back in 1888, when I was posted in the Brazilian mission to the UN in Geneva, and I was invited to a meeting by DCI, my old friends Daniel O'Donnell and Nigel Cantwell. And I went to this meeting very curious, because I said, what is this? This is a meeting about children's rights? And my ambassador asked me, do you think it's really important to go? I think, yes, it is, because I want to know what it is about. And this was about Target 89. I realized that the group was working for 8 years. There was no progress. It was, in a way, doomed to oblivion. And everybody was a little bit, not engaged anymore. And then came this initiative called Target 89, because 89 would be 10 years from the International Year of the Child and 30 years from the 1959 Declaration on the Rights of the Child. So we established that limit, but we decided that this would not mean that we would lose quality in the text. So this was our main concern, to work, to try to make it until 89, but to keep the quality. So what we needed to succeed would be a new and visionary spirit, an inspiration, and even a revolutionary vision. And I wanted to bring you back to these feelings that I experienced at that time, and I think they are still alive today. We believe that we could change the paradigm. We believe that we could change the concept of a child from an object of care and protection to a subject of rights. This was revolutionary at that time. And we had to believe that it was possible to do it, that countries would agree on that. And it was possible. And we had to believe that it would happen. And it happened. And we are here 25 years later, a little bit older, but still working for children's rights. And what we did a document with credibility. We did a document which would become an international law containing the highest possible level of rights acceptable for the maximum number of countries. So this idea that the document should be as universal as possible was already present. And we see today the wide process of ratification, which was the widest in the UN at that time. So the convention became a bridge. All these negotiations became very difficult, but there was this spirit. We have to find a way. We have to find a consensus. We decide that each article should be adopted with no voting. So you can imagine the difficulty to negotiate all those countries to arrive at a consensus that would be at the same time the highest level and at the same time possible to be acceptable by most countries as it is today. If I had to define the working group at that time, I would say a search for commitment and consensus. There was a huge effort for compromise between different and sometimes opposing and even totally divergent views, ideas, perceptions, and positions with no loss of quality, of course. There were long, extensive, and sensitive diplomatic negotiations. And here my colleagues in the working group may bear testimony of this. We needed to find a way of putting together countries with different political, social, juridical, philosophical, and religious traditions and systems and cultures. And of course, the participation in the working group was very asymmetrical, was that those words in English? Because it was based on the membership of the Commission on Human Rights. And it changed through the times. So we had different countries sometimes participating. We had countries with big delegations, and we had countries with only one person. And this was very difficult because at a certain moment, to accelerate negotiations, we created subgroups for specific themes. And then the delegations represented but only one person would have a lot of difficulty. I would like also to emphasize the role of UNICEF. It was a little bit reluctant at the beginning, but later was very active. You may remember the change of mandate of UNICEF. And in Article 45, it was mentioned by name, and it gave UNICEF leadership in this process, and later on in the process of setting up a system of international cooperation. The NGOs were very active outside the room. So we would go outside the room and discuss with NGOs. They would give suggestions, proposals. And at that time, you may remember, this was 88 and 89, before the 93 Vienna conference. So this was totally new. Later on, NGOs created the NGO group, and this was part of the committee work. During the second reading, it became very polarized, and negotiations were very accelerated. In a way, countries who did not believe that there would be a convention start to be suspicious that it would be a convention. And then they start to be very concerned. So some countries that had never been there appeared all of a sudden and were very interested in a process that was very, very long. There were huge political interests. Some of the issues of contention were, just to mention a few, freedom of thought, conscience, and religion, international adoption, minimum age for participation in armed conflict, rights of indigenous children, a big interest for Latin American countries, status of the child before birth, that there was a compromise and put on the preamble, concept of the family, practices affecting the health of the child, gradual implementation of social, economic, and cultural rights for developing countries, and the monitoring mechanism, mandate, composition, function, and financial. And last but not least, the role of international cooperation. On the basis of the realization of huge differences existing between rich and poor countries, when I was already in the committee, which I call the heroic years of the committee, for me at least, I tried to participate according a few rules, let's say, personal rules. First of all, I tried always to be very faithful to an open and transparent dialogue with delegations of states parts. And I think this was the spirit of the committee. It was not a tribunal. Many countries were afraid that we were setting up a tribunal to judge countries. And we wanted to make them understand that this was an open dialogue, a conversation, that we would like to identify obstacles and difficulties, not pointing out, but trying to identify together, and then trying to find the best and most effective solutions. And then we start to work with UNICEF, UN agencies, NGOs, for the setting up of this system of international cooperation in the committee, which was totally new at that time, I may emphasize. There were no treaty body that would do it at that time. Later on, I know that it's widespread, but this was still discussed as a new, innovative method of work. The committee opened the door, a new door, to a process of technical cooperation involving governments, UNICEF, UN agencies, and NGOs to follow up on concluding observations, an innovative mechanism that had never been established before. The fact is that international cooperation, as you know very well, it's at the roots of the UN. But as it was set up in the committee, it became a crucial link and a common element between the concepts of development, democracy, and human rights, creating a new impetus for the process of implementation at the national level and the process of democratization of international relations at the international level. It gave access, 1 minute. It gave access to children from developing countries, not only to development itself, but also to respect and protection of their human rights and fundamental freedoms. Furthermore, it created a bridge between lofty ideals of the Convention and the practical mechanisms which operate in the real world. It generated a partnership within the committee, as I have already said, with UNICEF, UN agencies, etc., and last but not least, governments for joint action. Technical cooperation and assistance became the distinctive principle of the mandate of the committee and the mark of committee's work. It emphasized its affirmative character as a treaty body projected to the future within a view to improving the situation of children around the world. Further on, if I have a chance, I still want to feel a few words. Okay? Thank you. Thank you. Thank you.
Thank you so much, Marilia. It's beautiful to be brought back and to feel so proud about everything that has happened. And I think that makes a wonderful bridge now with the chair of the Committee on the Rights of the Child, Kirsten Sandberg, who will now take the floor. Please.
Thank you. I didn't see this. We've just heard about the spirit behind the convention of making children rights holders. And in order to make children rights holders to the greatest extent possible in line with adults, we had the third optional protocol adopted a few years ago, and as we all know, it was ratified by enough states so it could enter into force in April this year. So to talk about the motivation behind this protocol was, in the first place, to make children really rights holders and not different from adults in that respect, because under all other conventions there was a possibility of giving complaints to an international body. And secondly, for children to be able to seek redress or to have somewhere to turn to if there are violations of their rights within the country and nothing is done within the country, you need somewhere to turn to, and children should have that right. Then thirdly, to hold states accountable. We do try to hold states accountable through the review process, the reporting process, but we know that it's they are accountable to a certain extent, but not. We don't have anything really in individual cases. And that's also, it's easier to hold the states accountable when the committee can look at individual children's rights. in individual cases. But this is not all. It's also, and maybe even more important, is that this optional protocol should inspire or influence the states to not violate children's rights. Because if they know that they can be brought before the committee, they might be even more interested in implementing children's rights. And also, they should be inspired to create complaints mechanisms within their own countries. So they should give children access to justice inside their countries, so that the countries know, so that children do not feel the need to go all the way to Geneva. We don't want thousands of complaints to Geneva. What we want is for the cases of possible violations to be settled somehow at home in their own countries. So what we hope is that this possibility for children to take their cases to Geneva will actually make countries establish proper complaints mechanisms for children, and also to give them easier access to the courts. Not that I think that in general courts are the best place for children to go, but anyway, that needs to be done. If you're going to complain to Geneva, you need to exhaust all domestic remedies, and that means children must have access also to the courts, meaning they would need to have the right to legal aid. They would need to possibly have a representative appointed other than the parents, if the parents don't want to support them. They need child-friendly procedures within the courts. There might also be the possibility, a greater possibility of friendly settlements between the government and the child within the court, but that would really put a responsibility on the judge to see to it that children's interests are not overrun in such a case. So we have to be a bit cautious about the friendly settlements with governments with regard to children, I think. On the other hand, the best thing would be if cases could be settled without having to go to court at all, through the complaints mechanism, for instance. And we know that, for instance, the ombudsman or ombudsperson of Ireland does a lot in order to have complaints settled, and most of them are settled through the interaction with the government. I think that if states do put in place such systems of complaints and possibly also access to courts, they should have less to fear from ratifying the third optional protocol, because then their children wouldn't feel that need to go all the way to Geneva. We have got no complaints so far since April. And the reason is probably that violations or the facts that the child complains about have to have happened after that country ratified the optional protocol, which means also that the states don't have to fear that children will come or adults will come with things that happened many, many years ago, because they all have to have happened after the ratification. Well, so then what can the committee provide? At least we can provide, if we agree with the child, that the child will get not redress in the form of compensation, but a redress in the way of saying that you were right, that the government was wrong, and the government has to rectify the situation somehow. I think this is what I would like to say. I think it's really important that the governments do ratify this third optional protocol, and 14 countries have done it without, I hope, thinking too much about the risk they are running. But anyway, if they were thinking about the risk, they've done it all the same. And I would encourage all states to do that.
Thank you so much. Reminding us that children are people too is in fact going back to the essence of the vision of the convention. It's very good to know that we have 14 states parties, and from today we have 48 signatories to the protocol, and so we are very hopeful that this will continue. I now am very, very pleased to give the floor to Maud de Boer-Boukikyu, who is the current Special Rapporteur on the sale of children, child prostitution, child pornography. But we would like to benefit from Maud's insightful comments, reminding us of the excellent role that she played in the Council of Europe in bringing the Convention on the Rights of the Child into the jurisprudence of the important mechanism the Council of Europe has in the field of human rights. Please.
Thank you very much, Marta, and congratulations to all of us once again today. It's a wonderful day. All of us, but especially the children, but they have gone. They have lots of other things to do, I guess, and then listening to adults. But yeah, you've asked me to talk about the relationship between regional and global standards. And for me, there is absolutely no doubt that there is a need for strong links between regional and global instruments, in particular in terms of human rights standards. The opposite would actually be quite worrying. I would like to quote as an example the Council of Europe Convention on Violence Against Women, which has high standards, and the discussion which is currently ongoing at global level, whether there is a need for a global instrument. Fine, provided the standards don't go lower. This is absolutely essential, and I'm confident that that if such a decision to draft a convention on violence against women were to be taken, that concern will be present in the minds of the drafters and those who propose it. It's true that sometimes it is easier to come to an agreement at a regional level, but it's not always the case. And sometimes a global instrument is preferable, but then global and regional initiatives can and should become complementary. And I would like to give as an example the United Nations Convention on the Rights of Persons with Disabilities, which has entered into force in 2008, and the simultaneous existence in the Council of Europe of a disability action plan, which ran over the period from 2006 till 2015. They were really complementary because all Council of Europe member states who ratified the UN Convention, they could appreciate the potential use of the Council of Europe action plan as a tool, a political instrument, an implementation tool to help them implement the UN Convention. So I think this shows how the two things can go very well together. But now let's return to children's rights, because that's what we're here for today. And just as a reminder, the Convention on the Rights of the Child coexisted when it came into being with the European Convention of Human Rights, which by that time was already an old lady of 45 years, an adult, let's put it that way, because it was drafted in 1950 on the ashes of the Second World War. And that convention, the European Convention of Human Rights, actually contains very few explicit references to children's rights. As an example, education is not formulated as a right of a child, but it is formulated as a duty incumbent on the state to provide for education. No explicit reference to children. Even the right to liberty is restricted for minors for educational purposes. That is mentioned explicitly in the convention. It wouldn't be as obvious as it is today, and certainly not for the Convention on the Rights of the Child. So, without wanting to be too critical, it's not a particularly child-minded text. So what it needed was inventive and dynamic interpretation methods to meet children's needs and rights. And this is a process which I've seen happening because I was previously working in the court, and I contributed also to the case law of the European Court of Human Rights. First, you have a set of rights which we qualify as absolute rights: prohibition of the rights of torture, right not to be treated in an inhuman or degrading way. And for these absolute rights, the court was very just as open as to the concept of rights as it would have been for adults, and so there were complaints in relation to corporal punishment, from judicial corporal punishment to corporal punishment in schools and in the homes, eventually, which was a judgment which the last judgment in that respect was in 1998. Where the government was arguing that corporal punishment should be accepted when it could be qualified as reasonable chastisement. Is Peter still in the room? Yes. Yeah. And all the court had to do was assess whether the threshold set by Article 3 of the European Convention of Human Rights had been reached. And it did conclude that there was a violation, and in doing so, there was a very explicit reference to Article 19 of the Convention on the Rights of the Child. I'm just giving you a few examples because I'm afraid we haven't got much time, but let me then say that the situation was a little bit more complex when it came to balancing conflicting rights and interests. For example, when the court was dealing with complaints by one parent in relation to the denial of the right to custody or care over his or her child, following decisions by domestic courts about and claiming the right to a breach of the right to respect for family life. And in the early days of the court, these issues were really more about adults' rights over children than rights of children. The court didn't listen, didn't hear the children. They were not party to the proceedings. Neither were they before the domestic court. So the children were nowhere. And the court was far from looking at children as individual holders of rights, and the best interest of the child was often simply not to alter the status quo, and the lapse of time decided the issue. And what was particularly worrying when the court took such a long time to rule on these cases. So basically the decision had to be, at the end of the day, leave the child where he or she is. It's too complicated to change, and let's leave it as it is. But since the entry into force of the Convention on the Rights of the Child, the approach by the European Court has really evolved, and the need to take into consideration the child's opinion is more and more decisive. And in doing so, the court uses extensive reference to the Convention, Article 12 of the Convention on the Rights of the Child. And the general comments of the CRC on the best interest of the child are also used as in examining these cases. The same is true for the reference to the Convention on the Rights of the Child is for juvenile justice, making deprivation a measure of last resort. So far, for the European Convention of Human Rights, we have in the Council the Council of Europe has also a revised social charter, which was revised in 1996, and that was really very much inspired by the Convention on the Right of the Child. There are many more child-friendly provisions, example on corporal punishment, on child labor. Just to give you, to show that there is a real complementarity between global and regional initiatives, also at policy level when it comes to children's rights issues. And I would like to recall the regional consultation which preceded the study by Paulo Pinheiro, after which the Council of Europe designed, together with children, a program called Building a Europe for and with Children, with two strands. On the one hand, building children's rights, and on the other hand, tackling the issue of violence against children. And so that program was then also in its implementation directly linked to the CRC, and the Council of Europe launched plenty of initiatives, bearing in mind the requirements of the CRC, the Lanzarote Convention on Sexual Abuse and Exploitation of Children, a anti-corporal punishment campaign, and there were references to the CRC all through. Personally, I attached very much importance to have exchanges with the CRC to implement our program, meetings with the UN UNICEF Executive Board, meetings with the Office of the Special Representative of the Secretary General on Violence Against Children, in particular the ones where she organized the meeting to confront and to bring together regions to confront their regional policies. So what I would like to say in conclusion, that I believe that, a regional program like the Council of Europe program Building a Europe for and with Children can be seen as a regional implementation tool for the Convention on the Right of the Child. So these are all examples of cross-fertilization. And to come back in conclusion to the European Convention of Human Rights and the CRC, I think that it is fair to say that both texts benefit from a dynamic interpretation. They are living instruments capable of taking into consideration the evolution of society. We have plenty of examples in the area of ICT, where the Committee on the Rights of the Child organized a day of general discussion. Yourself, Marta, you have just produced a fantastic report which relates to the issue of ICT and children and violence against children. Other UN bodies and institutions, including my mandate, are working on that. Parallel to that, the case law of the European Court on Freedom of Information and Expression evolves, taking into consideration these technological developments. So I think, in conclusion, that it is our ability to drive that evolution and doing that together, putting evolving capacity to work for the best interest of all children, which should be our target. Thank you.
Thank you so much, Maud, for this very rich overview. I know that only a few examples, but it shows the richness and the potential of these partnerships and how the best interest needs to be, again, the bridge between all this. And I'm so happy that this follows really very nicely with the next speaker, Ambassador Ahmed Fatala, permanent representative to the UN of the League of Arab States, but also a former member of the drafting group of the Convention on the Rights of the Child, a current member of the Human Rights Committee, and who chaired, in fact, one of the subgroups Marilia was recalling on the negotiation of a very important area in the Convention on the Rights of the Child, alternative care and the protection of children and the promotion of a family environment. We really want to hear about this and the League of Arab States, of course.
Thank you, Marta. I'm speaking as on my personal capacity, not as the ambassador of the Arab League. I would like to thank you on an official level for your cooperation with the Arab League, and on a personal note for our close cooperation for the last 30 years, because as Marilia said, I personally started the negotiation here in New York when I was third secretary, and then we ended it when I was first secretary at the Egyptian mission in Geneva in 1989. And no one was thinking about what is the site of the child, including my two ambassadors in New York and in Geneva. I will tell you first of all why this is important for the Arab Legion, because we have 45% of our population are less than 18 years old. Therefore, if we invest and if we implement the provisions on these people, 45%, we will have a better future and a better world in our region and all over the world. But if we don't invest in the children, if we don't implement what we agreed upon in the convention, I think that we'll have a generation which will not be very fruitful and constructive for the future of our region and the whole world. Therefore, I'll begin that the Arab world, and particularly Egypt, I was at that time representing Egypt, we were very active in in elaborating the convention. And as Marta said, as a chairperson of the sub-working group which dealt at that time with what is now Article 20, I can confess that due to the good intention and faithful cooperation and understanding of my other colleagues, some of them are here now, we succeeded together, and for the first time in the United Nations, in a United Nations document, to include the notion of kafala as reflected in paragraph 3 of Article 20 as one of the alternative care system. And this is what was due to really our cooperation. Therefore, we put on the same footing as the notion of adoption, and such approach ensures the upbringing of the child in his ethnic, religious, and cultural background. And this is very important to take into consideration. And at present, the right of the child issue is gaining more important in the Arab world. This can be witnessed by different summits, not only at the level of ministers. If we take the Kuwait summit in 2014, and then we go ahead what they have done, the declaration, the adoption of the Marrakesh Declaration, and what includes this Marrakesh Declaration. I will not go into detail. I know we can provide you with the Marrakesh Declaration, but what is important in Marrakesh Declaration is that it calls for adoption of national strategies to combat violence against children. And this is a very important point, in addition to making many references to the Convention on the Right to the Child. And then the efforts continued, and we had what we had in Doha Declaration. They adopted in the summit of Doha in 2013, and they have really emphasized the need to allocate resources and to facilitate the intervention to protect children in disaster and armed conflict zone. And this is important because we cannot speak about the implementation of the Right of the Child Convention, as I was just saying to Marilia, without having a secure world. Without security, you cannot implement the convention. Without money, without resources, you cannot also implement the convention. And without a system of social justice and democracy, we will not be able to fully implement the provisions on the convention. I'll go now quickly that for the recent years, we have children in our region has suffered and has been affected by tragic political instability. As you all know, they have been the primary victims. They have been killed, recruited, brutalized, used in armed forces, particularly by groups. And they have been separated from their children. You can see the cases in Iraq, in Syria, the refugee, the displaced person, and so on. I will leave a copy from my written speech here. I'm not reading from my speech. And therefore, the Arab League remained gravely concerned by the exposure of these children to the radical ideologies adopted by the extremist armed group in Iraq and Syria. And this is a very important element to see how children has been radicalized in our region and how the convention can be applied and how we should deal with this issue to go far from this radicalization of children. Such exposure poses additional threats and indoctrinate them to fight under false cover of religion in our region. This very negative situation in our part of the world poses new challenge to child protection actors, to the League of Arab States itself, and to the Arab parties to the convention to fulfill their obligation. How they can fulfill that obligation, having armed group dealing with this issue and no control over this armed group. The reintegration of these children also in a healthy society constitute an additional challenge because the special care and psychosocial assistance needed to achieve such aim is not always available, taking into consideration what is happening in the region. In this regard, the League of Arab States dispatched a number of specialized delegations in Syria and Iraq, trying to deal with this issue, to inspect the situation of the refugee children in the camps, and to study their living conditions, and so on. And also, in the same context, we prepared in the Arab League, in collaboration with Save the Children International, a document called Children Rights in Emergencies and Disaster Risk Reduction, and it includes practical steps to reduce the risk emanating and resulting from emergency situation and conflicts, especially with regard to their effect on children's rights. And the aim of the document, again, is to push the Arab countries to adopt national strategy to reduce risk in emergency situation. Such strategy should be incorporated into their public policy, and in doing so, the Arab state will guarantee the effective and sustainable protection for children's rights. Chers colleagues, the concern of the League of Arab States with ending violence against children reflects awareness of the negative result of this phenomena on development. As I said, social peace and the future of the Arab region. This position led the League of Arab States to establish the Violence Against Children Committee, and this is a very important committee. And in this, emanating from this committee, It is a technical committee and stemming from the Committee of the Arab Children. We have the Committee of Arab Children, and as a subcommittee, we have the Violence Against Children Committee. It meets twice a year. The task of the committee is to follow up on Arab and international efforts to protect children from all forms of violence. One of the most important achievements of this committee is the release of the first comparative Arab report on implementing the recommendation of the UN Secretary General study on violence against children, which was launched in October 2011 on the margin of the 66th session of the General Assembly, and the second report during the 67th session of the General Assembly. In the same context, one of the most important general decision and recommendation of the 12th General Cooperation meeting, which was in Geneva a few months ago in May, and I participated in this meeting, is that we agreed to be committed as League of Arab States and as UN to work together to collect data, undertake research through a desk review on the status and implementation of policies, laws, legislation pertaining to children's rights, and to establish criteria and indicators for the quality of early childhood programs. I see Marta is looking at me. I'll be quickly. I'm trying just to summarize. In addition, we agreed to prepare a strategy and plan of action for child protection in peace and security, and to convene a conference within the framework of the No Lost Generation strategy to provide senior children, to protect senior children from violence, abuse, and exploitation, and to provide them with protection, health, and education services. I will read the last part. I will not summarize. Dear colleagues, children in the Arab region, like children around the world, they are tomorrow's leaders. It is the responsibility of today's leaders to protect them and to ensure that they grow up in an environment of peace and development where the human rights of children are upheld and protected. It is not a choice, it is an obligation. From this aspect, and in an important step to enhance the protection of children's rights in the Arab world, to achieve a better future for our region where children can grow up in peace. The League of Arab States and the Office of the UN Special Representative of the Secretary General on Children in Armed Conflict signed a cooperation agreement in the margin of the 69th session of the General Assembly just a month ago. Excellency, ladies and gentlemen, in conclusion, I would like to state that the League of Arab States endeavors to urge member states to discuss child protection, enforcement of the right, ratify the optional protocols to the Convention on the Right of the Child, including the optional protocol on the involvement of children in armed conflict, as well as encouraging and urging states to lift its reservations to the Convention and its protocol. As Egypt, and as I was the one responsible for this issue of alternative care, although I was Egypt, represented Egypt, our parliament at that time made a reservation on what I have negotiated. But when I went back to Egypt, we lifted soft reservation. Thank you, Madam Chair.
Thank you very much. That's why we need you all along. We'll continue to lead. Well, this has brought us to the end of the interventions by panelists. I know that we are all pressed because there are so many events, but we have just a few minutes in case there would be any question or comment from the audience. Let us take 5 minutes. Could you get closer to the microphone, Rosalie, please? I would like to ask you to introduce yourselves, in case others don't know who you are, and be brief in your question or comment, but then others will follow. Thank you.
Rosalie Keach, League of Women Voters of the United States. Thank you very much, Marta, and the rest of the panel for this wonderful presentation this morning. A question: has anyone considered when I was many years ago having children, one of the things we had to do was go to a class on what to expect on having a child. And I was wondering if there is any thought to putting together a program where there would be training for new parents on children and the raising of children and the convention.
Let us listen to another question here.
doesn't. Now it goes, okay. I'm Görel Bogart for Plan International. Thank you very much. I have just two things that brought you took us down memory lane. And I was there too, not actually at the moment of the adoption, but just two reflections, and very brief. When you talked about the child-friendly way of going about things, I think that that's something that we can all make more out of in terms of getting the spirit going, because we all learn that the more child-friendly materials, the more child-friendly ways we have, the more human-friendly everything becomes. And I think that's something we should make more out of. And also to say that it's interesting that at some point 25 years ago, there were organizations that I was then not working with, who were saying, well, we don't work on human rights, we work on child rights. And and I think that's just a very interesting thing to see that that sort of has gone away, but that was actually a way that people were looking at it then. Thank you.
Görel. We will give now the floor to this side, to this side. Two quick interventions, and then we will see if we can.
Thank you very much. And thank you very much for sharing all of your experiences. I'm from the Mission of Monaco. We are very involved, and we wanted to thank you for everything you do, and in particular for the report I just saw for the post-2015. As Mrs. Bauer mentioned, the convention is dynamic, it's going to evolve. As you also mentioned, Ambassador Sandenberg, it's not a tribunal. What is the best way for you to put forward the issues of the protection of the child in the post-2015? Thank you so much.
Thank you very much. My name is Ibrahim Al-Shiddi from Saudi Arabia. I had the honor to be a member of CRC committee some years ago. We had a very good information about the history of the CRC. But after 25 years, how can we evaluate the follow-up procedure? I don't think that just reporting and meeting the delegation in Geneva, then sending the recommendation to the countries is enough to get the benefit of this excellent convention. I think we should evaluate by the United Nations, evaluate the ways to follow up the convention to be more beneficial for children around the world. Thank you.
Let us try to quickly organize some feedback from the panelists. Ahmed, would you like to address the question of good parenting and initiatives to support the best raising of the child in the light of the early child initiatives in the League of Arab States, or?
I think that the question was, it is how to address the issue in education, education or supporting parents.
No, it was the good parenting initiative to support parents to be the best possible before they need to be confronted with being a father or a mother and feeling completely at a loss. Right. Yeah.
No, I don't really have comments.
Well, but as we heard, the League of Arab States has now identified early childhood as a big priority, and we are all working together to make it work. It is a requirement in the Convention on the Rights, a beautiful perception of family, open but important. A triangle when the state and the family and the child all play a role. And as many have said, the best interest of the child continues to be the link, and everybody will be guided. And for parents to be the best parents, which they want to be, it's very important for the state to provide support that is required for that to achieve. Please.
Just a few words, because the issue is related to the issue of education. Because if you have parents, the issue is how to disseminate, first of all, this convention, how to address the society itself through seminar, workshops, and so on, and how to include it in the educational system, because the present student will be the future parents, and therefore how to include this in the education system, in the education system to get acquainted to it by the young people now, therefore they can implement it. in this issue also, I think that creating some mechanism in a national, on a national level, like it exists in Switzerland, can also push the people to respect the parents, to respect this. I remember I lived, as Martha know, 9 years in Geneva, and at that time I had my first and second kids one after the other, and they used to write when they went to the kindergarten the number of SOS children in their hand. And then this was, they was telling us as parents, we have SOS children. If you say something we don't like, we'll call the SOS children. And this was part of educating us as parents of how to deal with children and respecting the right of the child. Thank you.
Also, in relation to this issue, I would like very much to touch on the need to teach the convention in schools and the universities. Because if we had the teachers trained in the convention, what does it mean to be a teacher looking at the child not as a student only, but a subject of rights? I think this would be very important. I remember some initiatives were done in many universities in Europe. I don't know if in Latin America, etc. But I think this should be more integrated and more systematic, not a sort of fragmented initiative. Also, I would like to mention that being committed to the convention means being always committed. And we have to look at the challenges ahead. And I think this is very important. Someone mentioned here the Post-Agenda 2015. If we look at the holistic value and dimension of the convention, we have to think about integrating violence against children in the document. I know it's there, but should be there. Not only because it protects children from neglect, from abuse, from exploitation, but also because it is intimately connected to the holistic dimension of the convention. There is also, for instance, Beijing Plus 20 coming. This is another important opportunity open to the Committee on the Rights of the Child and all stakeholders to bring back this vision. The vision is there. We have to preserve it. We have to reaffirm it. Look at the child as subject of rights. Sometimes this is a little bit lost. Media could be very important in that respect. Not media with sensation and bringing only cases that would, in a way, call the attention of people, but bringing it into the dimension of the child as a subject of rights. It changes everything. If a pediatrician looks at a child as a subject of rights, it's different from being only a pediatrician that takes care of the child. He'll take care, or she will take care of the child, but because she has the right. And not because she's the future for the country, but because she's a child today. And she needs her rights today, not in the future. In the future, she'll be adult, and then we'll have the rights of adults. Thank you so much.
Maud, would you like to follow?
Very quickly on the last question in relation to the follow-up of the recommendations and the opinions of the Committee on the Rights of the Child, I think this is an extremely important issue. I mean, the cycle being what it is, I mean, it usually is, before the Committee on the Rights of the Child would return to the same country, a lot of time will have elapsed. So in my mandate as Special Rapporteur on the sale and sexual exploitation of children, I'm absolutely determined to make use of what has come out of the review procedure in the Committee on the Rights of the Child, both in my advocacy activities, which can be manifold, but also in the choice of the countries which I want to report on when I have the feeling that the follow-up which we could have expected from that particular country is not following. And then, of course, there will be an opportunity to have this interactive dialogue in both the General Assembly and the Human Rights Council in Geneva. So I think that would be a way, for me at least, to contribute to ensure a follow-up to the recommendations of the Committee on the Rights of the Child. That's what I can propose from my perspective.
Many thanks. I think we need to be bringing the meeting to a closure, but I would like to give the floor just for some quick comments and start with Anders and then John.
Thank you very much, Marta. Two very brief points. Don't forget children as educators. My experience from Sweden is that children are taught the convention in school and they go home and teach their parents about the convention, children as actors. The other thing I want to, if you are interested more about the legislative history, I would recommend this compilation on the legislative history of the rights of the child, Convention on the Rights of the Child, which can be bought, but it can also be, you can also get it on the internet free. It has been compiled by my good friend, compatriot Simon Ek at Save the Children. So I think she has done a great job in documenting how we negotiated the convention. Thank you very much, Marta, for this lovely event.
Thank you. Thank you. I'm so sorry. I know that a number of colleagues would like to take the floor, but unfortunately the room will have to be vacated because there is another meeting that will follow and we will need to be out. So let me start by thanking first the panelists for... Oh, Trond, I'm sorry. You had another final comment. Please. You were the only one not being given.
Thank you, Marta. I just wanted to say that I think it's a call for what we hear during the different kind of meetings here, but also other meetings which is on national level around, and that is, have we come to a kind of a dead end when it comes to the convention? Have we lost the spirit? And I think there is a need of a good research, interdisciplinary research, and especially when it comes to governance, or what is innovative governance for children. Because the implementation gap, which was mentioned by Thomas, I think that is becoming more and more stronger, and it seems to be there for a long time if we cannot address it. And that is the transforming process, so to understand both how we can change the society through politics and not organize the structure in politics in a way that it's really difficult to see the innovative solutions. And if we go into that dead end, we do really something wrong when it comes to set children in the front of the development for the future. And that is also then related to the mindset. So we need to encourage research, and we also need to bring ourselves into the mirror and look for where can we start working and bringing back the spirit. One thing when it comes to participation, the last thing is that one of the meetings I had in Norway when I was an ombuds, and we were talking about how we can use children to teach them, learn them about the convention, and they said, we don't want to learn about the articles, we want to live the convention. And that is a strong saying. What do you mean by living the convention? Yeah, we want to be involved in running the education, the school. We want to be involved in the employment process of the teachers. Because if the teacher comes into the classroom, normally they say, the kids, who are you? I'm the new teacher. And you start on this level. But if they are involved, the teacher comes in the classroom and he knows, she knows, they picked me, and vice versa. So there are ways, we should have many ways to explore how we can bring children much more into the center of policy making, much more into the center of daily living, and especially then with respect and dignity for the kids. Thank you.
So much, Trond. I think it was a lovely way of concluding. I have no doubt you will be even more convinced, if you would not be convinced when you enter the room, that we are before a visionary document, a living document that children want to live every day, but also a document that bridges so many differences and can help the world be much better by allowing us to invest in children. That's where the difference can be made. No one will be against it, and so many solutions that will serve everybody will certainly be at the heart of what we do and what we achieve. I hope the spirit will continue, that you bring the news of what we reflected upon, and that we will bring back this mission that was anticipated so many years ago, but that we continue to replicate across regions in all the professions that we may have. Many, many thanks for your presence, and thank you for being...
I hope that everybody will be here in 50.
Yeah, within 15 years, 50 years we'll be back, of course. But thank you so much. Thanks.